Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, as the title suggests, we're going to briefly discuss non-disclosure agreements here in the Kingdom of Thailand. Again, as noted, I'm an American attorney. I'm the Managing Director of the firm. I generally tend to act as a liaison in matters pertaining to Thai law specifically. We have Thai attorneys on staff here at the firm to assist in the specifics of, for example, drafting of a non-disclosure agreement. This video is simply here to provide sort of a brief overview of non-disclosure agreements sort of generally and provide a little bit of insight to the viewer about how they're going to work and the steps that one probably is going to want to take with respect to getting a non-disclosure agreement drafted. So the first thing to think about with respect to non-disclosure agreements is this. Unlike non-compete agreements here in the kingdom, non-disclosure agreements are kind of a horse of a different color. As noted in a prior video on this channel with respect to non-compete agreements, Thai law tends to take a less than rosy view with respect to non-compete agreements, basically based on a paradigm of free movement of labor, for lack of a better term. With respect to non-disclosure agreements, we're talking about a horse of a different color, especially where the non-disclosure pertains to things like patents owned by a given company or individual, trademarks, trade secrets, trade names, and just basically general specific information to a given industry that may only be had by one given company or one given individual. There, in my opinion, seems to be a general impetus to go ahead and protect such information, at least in a legal framework, because doing so, especially by those who've consented to not disclose that information, doing so is going to be better for the business community as a whole, for lack of a better term. It's kind of a policy perspective. If everybody knew if you couldn't rely on a non-disclosure agreement with respect to, say, the formula for making Coca-Cola, just pulling that out of the air, it would be very difficult to run a business selling Coca-Cola because one would be constantly looking over their shoulder, worried that specific trade secret would be stolen. So for that reason, this jurisdiction, at least from sort of my outsider's legal perspective, much like many other jurisdictions, I think takes the view that, look, we want to encourage business, and there are going to be certain types of information that need to be kept secret in order to maintain the competitive advantage of a given business. And someone who's not been involved in the creation of that intellectual property or the creation of that information, whatever you want to call it, someone who's not been privy to that, it's not really in a position to be able to enjoy the benefits of that information or that intellectual property by windfall. This is especially the case where an individual consents by signing a non-disclosure agreement to basically being restricted with respect to how they can disclose that information or if they can disclose it or use that information at all. That being said, with respect to non-disclosure agreements generally, it should be noted that it's a good idea to have these agreements drafted correctly so as to ensure that they are as binding as they can be on the person or entity involved. And also, there's a transparency issue. And also, I think there's a good business aspect at play here too, where it's simply a matter of, look, we just want to, we as the party holding the information that we want kept confidential, we want to be very clear as to what we want kept confidential, and also we want to be clear as to our relationship with the counterparty. We don't really want to create a bunch of friction, drama, if you will, controversy down the road based on flying accusations of disclosure, etc. Let's just set a framework at the outset so everyone understands where they stand and everyone understands exactly what information is considered confidential and therefore subject to a non-disclosure agreement or NDA, and we'll go from there. So it's a good idea to have a legal professional draft up one of these instruments. It's also a good idea to understand what one's trying to protect from the outset so as to best place themselves in a position to not only be as transparent as possible with their counterparty as to what exactly is being protected, but also to just forestall unpleasantness down the road.